Welcome to the Probate Nation. My name is Richard Ruddy, and I'm the host of the show this evening. People are living longer thanks to good health care and healthier lifestyles. But as we age, not everyone remains as sharp as they were earlier in their life. And frequently, a loved one, a son or a daughter, is called upon to handle the financial affairs of an incapacitated elderly parent or family member. There are many ways for you to acquire that legal authority to handle those assets and affairs when they become incapacitated. One of the best and most comprehensive ways to do this is through the execution of a durable power of attorney. This document is a powerful tool and should forestall the need for court action to be appointed the conservator of the assets of your loved one should they become incapacitated. Our show tonight explores some of the common questions to consider in preparing a power of attorney, from whom to appoint to act on your behalf, what happens if they are not around, and when should they have the powers you are giving to them, execution requirements for the power of attorney, and practical consideration in using a power of attorney and dealing with certain types of assets, and much more. Our guests tonight are two Virginia attorneys, and they will guide us through this discussion. Our first guest, whose office is located in McLean, has been practicing law in Northern Virginia for over 40 years. His practice focuses on estate planning and administration, and he is the chair of the McLean Estate Planning Council. Our second guest is the managing member of Magner Law PLLC, located in Leesburg. He specializes in trust and estate planning with an emphasis on guardianship and conservatorship. He is certified by the Supreme Court of Virginia as guardian ad litem for incapacitated adults and receives GIL appointments in the 20th Judicial Circuit. Please welcome attorneys Emery Hackman and Jim Magner. Gentlemen, welcome.
Welcome.
We're going to talk about a very, very serious topic, durable powers of attorney. So, Emery, let's talk about what is a power of attorney?
Power of attorney is a device for which someone else can make decisions for the person signing the power of attorney. We use them in the light of incapacity in the modern era. Way back yonder when they had sailing ships, they were used all the time in other ways. Now, with cell phones and the internet, they're only used when somebody's incapacitated, either by declining mental ability or because they're under anesthesia for surgery.
So, Jim, tell us, how does a power of attorney become durable, and why is that important?
Well, the fact is that in ye olde times, and still for some specific purposes, you can have a power of attorney that's for a specific purpose. But for estate planning and for situations where we've got somebody who's incapacitated, the durable power of attorney is durable in what that means is that it's always in effect, and it stays in effect whether they come in or out of the incapacity, what their condition is. And it gives the person the ability to, who's making that durable power of attorney, to appoint somebody and then not have to worry about it again. It's not a specific appointment.
Okay. So I know there's a Virginia enacted a Uniform Power of Attorney Act several years ago, so the presumption now is any power of attorney is durable unless we've stated to the contrary. So you've talked a little bit about the purpose of a power of attorney, which is to help someone handle the affairs of a person when they become incapacitated. What happens if someone does not have a financial power of attorney?
If the case is extreme enough, somebody has to go to court to appoint a conservator and or guardian to act, because there isn't a power of attorney when the person cannot act on their own behalf.
Okay, so that means we're going to have to spend money on lawyers, and that, we've discussed that process in other shows. You know, the process is a little bit different in each of some of the local jurisdictions, but it is a time-consuming process, and it is an expensive process. Expensive
and terribly difficult for the patient, the client, the victim. All those words apply to the same person, because somebody has got to go interview them, and all too often they have to come to the courtroom, and they don't understand it because they lost their capacity. They're terribly embarrassed, angry. It's awful. Do anything to avoid that.
So it is a good idea. This is a powerful tool. We want to make sure we do. Let's talk about some of the features of the power of attorney, Jim. Who should be your agent under a power of attorney?
Well, this is a big question. In my clients, I know this is a problem, because many of them view this as a ceremonial or an honorary type of position, and they don't realize that you're giving somebody a very, very important job, and that's somebody who's going to be not only in charge of your finances, but actually charged with the duty of protecting those finances and managing them wisely. So when you're selecting a person to hold this power, you really need to think twice about who that's going to be. Oftentimes it's a family member or a child, but it doesn't have to be, and sometimes that's not the right decision. But many clients, I think, are afraid of not appointing somebody because it'll hurt their feelings. It'll make it appear as though they favor one child versus the other. This is not the time to be sentimental. This is not the time to be worried about hurting feelings. This is a very important job, and it's one that, if it gets fouled up, can cause a lot of harm.
I think you make a very, very good point that this is not a time to be worried about feelings. This is about doing what's right for you, the person who's granting the power. Now, Emery, we talk about appointing an agent, but a lot of folks have joint agents. Should you have joint agents?
The question I ask clients is, who will hold your hand when you're on life support? That clears out a great deal of discussion that's just not up to. I much prefer a power of attorney that appoints 2 or 3 people, any of whom can act concurrently, because we don't know who is going to be available when the client's on life support in the hospital. Your favorite choice may be yak packing in Bhutan or something, and just not there. Mm-hmm. So it's not joint. Pardon me. Joint to me means they have to agree on the decisions. I don't want to do that because we're standing in the hall of the hospital. The doctor comes out. 90% of the time, the condition is obvious. The doctor says, fine, that's what we're going to do. Then the other 10% of the time, my voice spikes on that. And now half of those, we'll work it through. We're down to 5% where, I don't think so. Show me the medical records.
Amber, you make a good point, though. I mean, joint agents, and again, in these financial powers of attorney can be very helpful because you're not sure who's going to be around when you have to have business decisions made or access to assets, maybe pay bills and so on. But let's talk about if we don't have joint agents, Jim, should we have successor agents?
Yes, and I think this is important clarification because a joint agent, you need the agreement of both parties, both of the agents, and many times that will cause, particularly financial institutions, to freeze up if one of the parties is trying to accomplish some task and can't do it because the other agent is not available. Successor agents is really the better alternative, and that's where if Bob isn't available, then it's Mary, and if Mary's not available, then it's Sue, and if Sue's not available, then it's John. There's a clear delineation of that order of succession in your agents, and it's very easy to tell who has the power to speak, but only one of them has the power to speak at that moment. So if Bob is off yak packing in Bhutan, then we know that Mary is going to be up, and she's going to be the one who's able to make that decision. It's very clearly laid out in the power of attorney.
Let's continue on that topic, though, because being able to contact the people that are listed there becomes an incredibly important piece of information. So some of the older powers of attorney, you would see naming a person and give the city and state where they live. Nowadays, though, we're seeing a lot more contact information being contained in the power of attorney. Do you recommend cell phone numbers, email addresses, that kind of stuff to be added into the?
I don't. The way I view the power of attorney should be clear enough to identify the person. Okay. That's the purpose. The contact information, because you're going to share that power of attorney with somebody at the bank teller, the person at the financial services place, or the real estate agent. And so unless somebody really consents to having all their personal private contact information being out there. But the purpose of the information that you do put in the power of attorney is to very clearly identify so there's no question about who has that power. However, you also need to advise the clients to make sure they have the contact information available, maybe not in that document spelled out for the public, but someplace where they can be gotten a hold of, because it's useless to have Richard named as the power of attorney if nobody can find Richard.
Sure, that makes sense. Now, Emery, you mentioned when do the agents that are appointed have the power to act? So I know we can either make that power immediate, or we can also make it, you mentioned something about a springing power. Why don't you talk a little bit about that?
I do it differently, but from experience. And the experience goes back multiple generations of Virginia attorneys. What I tell the client is don't distribute the copy, because the appointment is effective immediately, but it's not effective until that designated person has the copy in their hands. So just don't send it. Tell them where they can find it when they need it. That's fine. In fact, we hand them a red file folder. Tell them it's in the red file folder. In that place, though, dear client, please put what you need your agent, power of attorney, in fact, to know the moment they need to know. They don't need to know that stuff now. They don't want to know it now.
Sure.
But the moment they have to act for you, they need to know your medical conditions as of before whatever happened. Need to know where's the bank accounts. If you're an electronic banker, that means website, username, password. My clients generally a little older. They don't do electronic banking.
Sure.
Fine. So where's the banks?
Well, that's all.
But don't hand out the copy, because when you need to revoke it, replace it, you have to get the old copies back, and that is not a reliable process.
Sure. Okay. Well, there's that's what we call, a lot of times we'll have what's called escrow power, where basically it's a self-escrow where you're holding on to it. Then we also have what's called the springing power, which actually has a condition that's got to be met, which can lead to litigation in and of itself, right, to whether the condition's been met. Let's talk about some special issues to consider when granting authority, Jim. Power of attorney to deal with real estate.
Okay. Well, in Virginia, the statute is clear that if somebody has a power of attorney and it's listed in that power of attorney as one of the powers is to buy, sell real estate, encumber real estate, then they have the statutory authority to do it. What we find in practice, however, is that real estate agents, title companies, escrow companies, they're used to seeing a specific power of attorney that is prepared by the real estate section of the bar that everybody uses. And they're used to seeing that form. And if they don't see that form, we tend to have problems with them honoring the general power of attorney. So we try to add those other documents. They're not needed statutorily, but we do it as a practical sense because it's easier than fighting with somebody later on. So we try and add those powers of attorney. The difficulty with the real estate power of attorney that the real estate section of the bar puts out is that it has a finite duration. It says that you have this power from this date to that date, and it's really giving somebody the power to sit down at closing and sign at closing. It's a little bit more complicated to do that prospectively for the power of attorney, but statutorily, I suppose that there shouldn't be a problem with the person who has the general durable power of attorney going and getting a real estate power of attorney if it's listed there in the power of attorney document, and we want to make sure that it's always listed there.
Sure. Let's talk about estate planning. You know, power of attorney that grants the person the ability to do some estate planning. Do you include those provisions in your?
Very much so.
Okay.
Thoroughly encouraged by case law that's been misread recently. Yes, the courts will uphold if you grant the power and the power of attorney to form a trust, revise a trust, revoke a trust, add assets to trust, the courts will uphold it.
Okay. Dealing with Medicaid, how about Medicaid planning? Is those types of issues addressed in your power of attorneys too?
Generally not. We want to do that separately, and the reason is because the Medicaid rules themselves are very, very specific, and so we want to make sure that the Medicaid, if we're doing a Medicaid asset protection trust or some kind of Medicaid planning, we want to make sure that that specific document is very aligns very closely with the federal statute and with the state statute. So the power of attorney will defer to that because that's just a very specialized document.
Okay. Let's talk a little bit about creating the power of attorney. Okay, Emery, do powers of attorney have to be reduced to writing?
That's a really good question. I don't have a really good answer, but nobody understanding this would do it other than in writing and other than notarized.
Okay, and generally we want to have, we probably would like to have a witness if we could, but certainly have it notarized in case we need to record that power
Certainly
of
at
attorney.
least notarized. Certainly at least notarized. I would not recommend doing it without it. I don't know that it would be accepted. Certainly very sophisticated financial institutions in your banks simply won't accept them.
Sure, sure. So and then we talked about when a power of attorney becomes effective. Is a copy of a power of attorney an executed power of attorney the same as an original?
In my experience, yes. And the more life goes modern, these things are passed around by email attachment. Like you're in the I-95 in an auto accident in South Carolina, nobody's going to run around and try to find the original. They're going to email somebody, say, please send, and the attorney, if they're asked, has a little due diligence. Is my client really in the hospital? And if they are, yes. And I use witnesses because some states require witnesses, and I'm not going to get them to figure out which state does and which state doesn't, which country does and which country doesn't. At least one place in there have some witnesses.
Okay. Now certainly you have to have an original power of attorney if you want to go to record and Milan records. They're not going to record a copy typically.
That's correct. Yeah, you've got to have original wet signatures still. There are some things that were still throwback to the 1800s, which is fine. And I think technically, if you look at old case law, the copy is not as valid as the original because there's always a possibility somebody has revoked it. But I think my colleague's answer earlier is don't give out copies. They can get the copies when they need them, but don't give out copies. That tends to cut down on that. But in reality, when you're dealing with multiple financial institutions, you can't hand that original one around to everybody, so people are getting copies, and they're generally accepted.
Sure. Sure. Well, we talked a little bit about this, Emery, but let's go over it again. What should you do with your original power of attorney once it's been executed? Let's just emphasize that again.
We used to say put it in a safe deposit box, but we used to have to drill the clients on don't put it in a safe deposit box in the District of Columbia because they won't let the safe deposit box be opened. And we used to tear our hair about it. I've heard more recently and have adopted, dear client, buy a fireproof box. Put it in the bottom of the house someplace, put the original in there. If they ever really need it, they can get the locksmith to open it, and it's much more secure than any place else. We used to leave it with the attorney's office way back yonder when. Well, when Northern Virginia was effectively 2 circuits, Alexandria and Arlington, it wasn't too hard to call around and find the 10 attorneys that did this. We now are at least 7 jurisdictions in Northern Virginia, and the attorneys sitting here are some of the best ones, but there's another 2,000 of them. And Fairfax is 5,000 members of the Fairfax Bar. You can't do it that way anymore. So I stay away from safe deposit boxes where the client, frankly, has to renew it. The bank can't find anybody. They drill out, throw the papers away. So I've gone to recommending a fireproof box. Costs $200 at Home Depot.
Okay. Well, I certainly know we used to hold estate documents early in our career, but we don't do it any longer because we have to now go find them and give them back to them, and so that can be a challenging process. Let's talk about termination of a power of attorney. Can a power of attorney be terminated?
Certainly. Unlike a will or a guardianship or conservatorship, when you give somebody power, you always have they don't replace your own power. You have the same power that they do. In most cases, you're incapacitated and can't exercise it. But if you can't exercise it, you're at a point where you're not incapacitated. As long as you're not incapacitated, you can always revoke or amend a power of attorney.
Okay. Now, some events, for instance, obviously, if you die, your power of attorney is revoked because it's no longer active. It ends on your death, and that terminates automatically. Does divorce or separation terminate the power of attorney now?
Some people think it does. It terminates wills, but it's not so strong on terminating power of attorneys. If you didn't hand out the copies, the best way to revoke power of attorney is destroy it.
Sure.
Rip, throw in trash.
Absolutely.
People do sign documents say, I hereby revoke my power of attorney signed on pick a date. But that's not effective because the person with it can show up at the bank, at the hospital, the whatever, financial house, with it, and they don't know it was revoked. So to really revoke it, you've got to get all those copies back.
Sure.
Destroyed or not.
Certainly the power of attorney can have a date when it actually terminates by its own volition, in which case it automatically ends.
Certainly. It's really wide open what you can do, and attorneys can get creative in what we do with powers of attorney. In fact, in this case, we still use them sometimes when you have a family with young children and they're going overseas either for work or for travel or something, and they want to grant a power of attorney with regard to the care of their children. And so many of these types of power of attorneys, we may have a specific period that they're effective, or in the case of a springing power of attorney for an estate plan, it might only be effective during the time that somebody's incapacitated, and then it goes back in the box after they're no longer incapacitated. Again, there's other legal issues of whether or not those conditions have been met, but certainly you can get very creative with them. There isn't a sort of set rules. It's really an open-ended field, and attorneys can be as creative as they need to be for their clients.
I think it is a powerful tool. Well, let's talk about some of the issues to consider. Nowadays, there's forms for everything. Okay, I mean, as long as you have access to the internet, you've got a lawyer. Some people think. So let's talk about that. Is there a single appropriate, durable power of attorney form?
In my giving speeches around Northern Virginia, frequently with another speaker, I've discovered all of us have our own favorite, and they're all different, and it drives me nuts. You would think some things would be standardized. Sitting here, I just know that yours and yours looks different than mine.
Mm-hmm.
Duh. It's just the way it is. We all start with the one we use as our standard start, get the names in there, whatever the information, go through and try to tailor it for the client. Now, this is partially an age prejudice. My clients tend to be almost my age or older, and they're telling me they didn't read it. Where do I sign? So I'm telling them, would you please read the first page and make certain the names are spelled right? They'll do that. So it tends to become a form, but it's not the form you'll find on the internet.
Okay.
The internet forms tend to match the state where the person who wrote it came from. California is very forms prone, but their form doesn't match Virginia's needs hardly at all.
Well, there is, Virginia has a Uniform Power of Attorney Act, and so there's a lot of provisions that are built in by statute now, which I know you folks incorporate into your practice. And so the written form, and that act addresses a number of issues, one of which is what if someone refuses to accept your power of attorney?
Well, you always have the right to refuse to accept power of attorney. You don't have to accept the job. You're not required to. Unless you're an attorney and the judge calls you up to the front of the courtroom one day, like it's happened to me a couple of times. But other than that, you always have the right to refuse that. If there's no backup, if there's no successor to do that, then somebody has to go ask a judge to appoint somebody. And you may end up back in a situation where you've got a guardianship or conservatorship issue. So when I'm advising my clients, I really try to get them to name multiple people. Sometimes the clients will say, well, I've just got the one child and I don't know anybody, I wouldn't trust anybody else with my finances. I might ask them, well, what about your banker? What about your financial advisor, somebody who is going to be good with money and understand the fiduciary duties and also be liable and have some means of redress if they go awry. But you always have the right to turn it down.
Okay. Well, I know that I ran into this problem a number of years ago. I know that the Act, the Uniform Power of Attorney Act, addresses one of the issues, which if I show up at a bank, which I had to do not that long ago with a power of attorney that's been signed by a client, and they refuse to accept it, I can take them to court, and if I'm successful in having a court order them to accept the power of attorney, then they have to pay my legal fees. So that was kind of a new thing that was incorporated into the Act. What happens, can an agent under a power of attorney be required to account for his use as an agent for that power of attorney? Is there an accounting obligation?
Yes.
And that's a process that can be triggered by a simple letter from just about anybody who's a friend or a relative of
They have to have standing to want to know, which really means children, maybe brothers and sisters. You get much further than that. The courts aren't going to enforce that. They just don't. Judges don't like these cases to begin with. They really don't. So if somebody was picking that big fight, pardon me, good luck and pay legal fees up front. Ain't gonna work.
Yes, that's true. Let's go. We've covered a lot of material. Power of attorneys are powerful tools. They can be used for many, many reasons. Let's get some final thoughts from you, each of you, about things you want to point out or some practical considerations you want to share. Emery, you want to start?
The most powerful question I've ever found is the question, who will hold your hand when you're on life support? If they'll answer that, the documents just flow and they work. If they can't answer that, no matter what I do, they're not signing.
Jim, how about yourself?
There is simply no reason not to have one of these. I don't care whether you're, a young person who's just got married and had your first kid, or whether you're a senior citizen looking at planning your retirement. There's just no excuse for not having one of these. We do them automatically. When somebody hires us to write an estate plan, we automatically include them. We don't even ask, unless they refuse to sign it, which I've never had happen. There is no excuse not to have this. It's just, it's just everybody should have one.
I agree, and I generally don't charge for power of attorneys because they don't revise them, but it's actually a way to get them into the discussion, and between 1 week and 1 year later, they're coming back because they realize they just made all the big decisions. Fine, we can go do it now.
Well, guys, thank you so much for taking the time and talking with us. This is a lot of information for our viewers to digest, but I want to thank you for taking the time and for the public service you provide to the citizens of Fairfax County and to the views of the Probate Nation.
You're welcome, and I think from both of us, it's been fun.
It's been fun. Thank you for having us on the show.
Been our pleasure. Thank you again. You know, a power of attorney is a critically important tool in planning for the incapacity of the loved one. It is intended to empower your duly appointed agent to handle your financial affairs and assets, typically when you no longer have the capacity to do so. Drafting the power of attorney, however, requires careful consideration and discussion as to both the breadth of the powers to be granted, to whom these should be given, and when should the power of attorney become effective. And the broader the powers, the more important to consider the merits of ongoing oversight to avoid the potential for an agent to commit undetected fraud. But remember that a power of attorney is not a form. Rather, it is a formula to empower someone to act on your behalf. And no one formula is right for everyone. I encourage you, while you have the capacity to do so, to have a dialogue with an experienced attorney. Let them help you compose a power of attorney that reflects your wishes so others can help you when that may be necessary. This brings us to the conclusion of our show today on durable powers of attorney. Hope you found it informative, and remember that replays of the show can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.